Good afternoon. My colleagues and I are here this afternoon to speak to you briefly about the presidential reference that was made to the Supreme Court and the judgment delivered by the Supreme Court, or more correctly, the opinion delivered by the Supreme Court yesterday. We are happy that the court held that the reference was maintainable. You will recall that a lot of controversy was kicked up on the motives of the government in making the presidential reference, and the maintainability itself was questioned very, very seriously and strongly. The court has held that the reference is maintainable. This you will find at page 70 of the judgment. The President had referred several questions to the court. The court has chosen to answer 5 questions. In fact, all 5 questions have been answered together. And the court says that actually question number 1 subsumes the first 5 questions. You will find that at page 81. The court has categorically held that the predominant consideration is the common good and not revenue maximization. It's possible that in a given case, revenue maximization is the goal. But it's equally possible that in several cases, revenue maximization is not the goal, or certainly not the first objective. There are other objectives that are equally important, equally compelling, and equally deserving of being pursued by a government. And therefore, the categorical declaration by the court that what will determine what is right and wrong is the common good. The court concluded it is the touchstone of testing whether any policy subserves the common good, and if it does, irrespective of the means adopted, it is clearly in accordance with the principle enshrined in Article 39. This you will find in pages 115 to 118. The court has also recognized that in the past, not under this government, but under previous governments too, over several years in the past, there have been cases where the government has not followed an auction. And several cases have been cited where the court has upheld the decision of the government not to follow an auction. The court has held that these cases have been correctly decided, that in the facts of those cases, auction was not the right method, and the government was therefore right in not adopting the auction method. These examples you will find at pages 126 and 127. The court, of course, has observed that where revenue maximization is the goal, auction is an attractive and preferred means of disposal. I think the words are very important and pregnant with meaning. Where the goal is revenue maximization, an attractive and preferred means of disposal would be auction. This you will find at page 131. And then finally the court has held that where economic policies are made by government, the court cannot and should not sit in judgment over those choices, because the court does not have the capacity or the resources to examine the correctness of choices, policy choices made by government. This you will find at page 140. So in every way, we believe that the position of the government that has been articulated over the last 2 years on different occasions from different platforms, sometimes in response to criticism and sometimes as an attempt to explain what government is doing, we believe that the court has observed and laid down principles which are completely in consonance with what the government has been saying over the last 2 years. So I thought I'll give you this brief introduction, and if my colleagues wish to add anything, I invite them to add, and then we'll take just a few questions. This is not a courtroom, nor a classroom.
Thank you. One of the submissions made in court, which has a bearing on the future allocation of scarce natural resources, was that in the case of a scarce natural resource, auction is the only method. And at page 112, the Supreme Court states the following: the assumption that alienation of scarce natural resources meant for private and commercial business, please note the words, meant for private and commercial business ventures should always be auctioned, has been rejected. So if there's a scarce natural resource meant for private and commercial business ventures, there is no mandate in the Constitution to dispose of that scarce natural resource through auction. It's a very important, salutary principle that the court has laid down at page 112. Number 2, court also says at page 112 that to derive auction as a constitutional principle only for a limited set of situations. Scarce natural resource is a limited set of situations. To derive auction as a constitutional principle only for a limited set of situations from the wide and generic declaration of Article 14 would be odd. That's at page 112. At page 113, distribution has broad contours, says the court. Distribution has broad contours. It cannot be limited to mean only one method, that is auction. Why? Because the word distribution is used in Article 39B of the Constitution, small b, which is part of Directive Principles of State Policy, which says distribution of the economic resources of the community must subserve the common good, as the Finance Minister has mentioned. Then, it's a very important statement which you will find at page 118. Very important statement. Please, I would like you to note it very carefully. It says, where revenue maximization is not the object of a policy of distribution, the question of auction does not arise. Now you know that many of the policies followed by this government and by previous governments has their foundation the principle that revenue maximization is not the object of the policy. And the court has categorically said, in that situation, the question of auction does not arise. That you will find, that statement you will find at page 118. Then at page 119, allocation of natural resources to the highest bidder may at times run counter to public good. It's a very important statement again. I'll repeat, page 119. Allocation of natural resources to the highest bidder may at times run counter to public good. Because if only the highest bidder is entitled to either the scarce or any other natural asset, only the rich will get the assets. And those who don't have the capacity to pay will never have access to those assets. So very important principle the Supreme Court renders in its opinion. Then, another very important principle was the argument has been that a policy can be subject to abuse. And if it is subject to abuse, it must be struck down. At page 131, the court says, potential for abuse cannot be the basis for striking down a method as ultra vires the Constitution. Merely because a policy may be abused cannot be the basis for striking it down. And more important than that, the Supreme Court says even auction has a potential to abuse. So if you strike down distribution without an auction, you can also strike down auction, because that too has a potential of abuse. Page 131 of the Supreme Court judgment. And last of all, methodology pertaining to disposal of natural resources is clearly an economic policy, as the finance minister mentioned. Auction as an economic choice of disposal of natural resources is not a constitutional mandate. So choice of the manner of distribution of natural resources is economic policy. And that cannot be struck down as violative of Article 14, nor does the Constitution mandate us to distribute natural assets through auction alone. And that's at page 141. And then at 143, alienation of natural resources is a policy decision. This is very important. Alienation of natural resources is a policy decision, and the means adopted are thus executive prerogatives. Remember, Supreme Court makes a distinction between policy and means. Policy and implementation. The court says policy cannot be touched, but the means can be struck down as violative of the Constitution. The implementation can be struck down as page 143. Therefore, the court says executive action can be termed as arbitrary, unfair, unreasonable and capricious. Policy cannot be declared as unreasonable, arbitrary and capricious, but executive action can. And the distinction, therefore, between policy and implementation, policy and executive action has now been clearly made by the Supreme Court. I just wanted to add that. Thank you.
आप सभी महान भाव को दो शब्द में हिंदी में अर्पित करता हूँ। हमारे साथियों ने जो सारांश है इस निर्णय का, सुप्रीम कोर्ट का दूरगामी निर्णय है, बहुत महत्वपूर्ण निर्णय है, उसको आपके सामने प्रस्तुत किया है। और निश्चित ही आप लोगों ने सबने इस पर अध्ययन किया होगा, जजमेंट को पढ़ा होगा। हम लोगों ने इसको बहुत गंभीरता से इस पर अध्ययन किया है और हम आभार प्रकट करते हैं अपनी कानूनी व्यवस्था का और संवैधानिक व्यवस्था का कि हमारे यहाँ बहुत ऐसे गंभीर प्रश्न उठते हैं जिस पर लोगों के अलग अलग विचार होते हैं और होने चाहिए, लोकतंत्र में होने चाहिए, लेकिन अंततः जो भी आदान प्रदान विचारों का होता है या टकराव विचारों का होता है, उसको अंततः उसका जो अंतिम निर्णय होता है वो भारत के संवैधानिक पीठ से होता है, उच्च न्यायालय से होता है, और ऐसा ही एक महत्वपूर्ण ये निर्णय आप लोगों के सामने आया है। और मैं आप सबसे निवेदन करूंगा कि आपके माध्यम से ये बात पूरे देश को पहुंचे कि हम लोगों ने बड़े विश्वास के साथ ये निर्णय लिए थे, और ऐसा प्रस्तुत हो रहा था, ऐसा हो रहा था, लग रहा था कि प्रश्न चिन्ह हमारी नीयत पे और हमारी कार्यशैली पर, पूरी कार्यशैली पे लगाया गया है। इसलिए राहत मिली है। राहत के साथ साथ विश्वास और उत्पन्न हुआ है कि हमने जो इस देश में जिस नीति को आगे बढ़ाने का प्रयास किया, उसको सराहाया गया है, और उसको स्वीकार करते हुए हमारे कानून व्यवस्था में जो उच्च न्यायालय है, उसने हमको आगे बढ़ने का संकेत दिया है, दिशा निर्देश दिए हैं। हम ये मानते हैं कि बहुत सारे इसमें ऐसे विषय हैं जिस पर और विचार करने की आवश्यकता होगा। कुछ प्रश्न ऐसे हैं जिस पर संवैधानिक पीठ ने हमको अपना निर्णय इसलिए नहीं दिया है कि उन्होंने ये माना कि हमारी अपनी पेशकश कोर्ट के सामने ये थी कि ऐसा कोई विषय जो पहले दिए हुए निर्णय से संबंधित हो सीधा सीधा, उस पर ना ही हम कोई प्रश्न उठा रहे हैं और ना ही उस पर कोई नई कार्रवाई की बात उठती है। ऑक्शन होगा, और ऑक्शन जिस तरह से हमको दिशा निर्देश प्राप्त हुए हैं 2G जजमेंट में, वैसे ही ऑक्शन होगा। लेकिन बहुत सारे और पहलू हैं जिस पर हमने मार्गदर्शन चाहा था सुप्रीम कोर्ट का, और सुप्रीम कोर्ट ने ये कहा कि आपके अपने निर्णय के कारण और जिस तरह से आपने उस बेंच के फैसले को ना चैलेंज किया है, ना आपको यहां पर चैलेंज करने का कोई अवसर था, उसको सामने रखते हुए और निर्णय जो है वो आप स्वयं कर सकते हैं और आप स्वयं करेंगे। तो ये कपिल सिब्बल जी, अब आगे समय जब मिलेगा तो इसमें इन सब चीजों पर समय समय पर आपको विस्तार से बताते रहेंगे। आज मैं सिर्फ इतना ही कहना चाहता हूं कि आपके सामने विभिन्न जो इस निर्णय के विभिन्न पहलू हैं वो आपके सामने रखे गए। मैं अपनी ओर से आपको पैराग्राफ 120 का मेरी जो फेवरेट लाइन इस जजमेंट की है वो आपको एक दफा दोहरा देता हूं, और उसी पैराग्राफ का अगला हिस्सा कपिल सिब्बल साहब ने आपके सामने रखा था, लेकिन शुरू का हिस्सा है, मेरी फेवरेट लाइन है, Therefore, in conclusion, the submission that the mandate of Article 14 is that any disposal of natural resource for commercial use must be for revenue maximization and thus by auction is based neither on law nor on logic. There is no constitutional imperative in the matter of economic policies. Article 14 does not predefine any economic policy as a constitutional mandate. Economic policy, अर्थव्यवस्था, अर्थनीति के संबंध में लोगों के अलग अलग विचार होते हैं, लेकिन जो चुनी हुई सरकार होती है जिसका दायित्व होता है कि वो सरकार अपनी ओर से जनता के हित में कुछ कदम उठाए, वो कदम अपनी सोच से जो सबसे अच्छी अर्थव्यवस्था होती है उसको बनाने के लिए पब्लिक पॉलिसी के माध्यम से प्रस्तुत करती है सरकार। और इसको एक बार फिर स्वीकार करते हुए सुप्रीम कोर्ट ने, मैं मानता हूं कि हमारे कॉन्स्टिट्यूशनल मैंडेट को और सेपरेशन ऑफ पावर्स को एक बार फिर मजबूत किया है, और इसके लिए सुप्रीम कोर्ट का स्वागत है।
Yes, Pallavi, please. Pallavi, please. Just a moment.
My simple question is, don't it be a little unfair that you're looking at the Supreme Court's verdict, your observation yesterday, as a clean chit to your government? Because the question is not of policy, the problem was also arisen over the implementation of the policy, whether it's a 2G issue or the coal issue. So on that,
go back and look at what we said over the last 2 years. We have consistently maintained that if there were any irregularities or illegalities in the implementation of any policy, those illegalities and irregularities must be corrected and those responsible must be held to account. We have never defended illegalities and irregularities. But the problem was, people pointed a finger at the government and said, the choice of policy was illegal. The choice of policy was irregular. And as my friend Salman just read the sentence at paragraph 120, that criticism is neither based on law nor on logic. We have never defended any illegality or irregularity, and investigating agencies, courts of law will hold people to account if they have committed any illegality or irregularity.
आपको इन 1 सेकेंड आपको याद होगा कि 1.5 साल पहले मैंने खुद प्रेस कॉन्फ्रेंस ली थी और उसने यही बात जो आज चिदम्बरम साहब कह रहे हैं दोहराई थी। जहां तक नीति का सवाल है, हमने सही नीति लागू की। जहां तक उसको लागू करने का सवाल है, अगर उसमें कोई गलतियां हुई, संवैधानिक गलतियां हुई, तो उस पर कोर्ट निर्णय लेगी। और जहां तक क्रिमिनल कल्पेबिलिटी का सवाल है, वहां प्रोसिक्यूशन होगी। ये बात मैंने 1.5 साल पहले कही थी और आज सुप्रीम कोर्ट ने तय कर दिया।
Mr. Chidambaram, the question is, sir, now that the Supreme Court has given a kind of sanctity to the government decisions, what do you think, sir, is the government in a position to kind of accept the contracts that the government has entered into since 1994, because there is a widely held perception that there is a witch hunt against this contract. And the contracts, we do not expect the contracts just to be restricted to telecom or to coal, because they are the two burning issues, but all the contracts that the government has entered into since 1994A. And Mr. Sibal, what happens to the issue of existing spectrum prospective charges, because it was widely believed that you are holding on to those decisions based on the presidential reference?
I think we should confine this media briefing to the judgment and not get into subject-wise or department-wise discussion, because the principles laid down in the judgment, which are really reiteration of well-known principles, principles that we advocated were the correct ones, but which was received with a great degree of cynicism. Therefore, I think we should allow each department to apply the judgment. Broadly, if the government of the day had adopted an economic policy and had entered into contracts based on that policy, those contracts would obviously stand unless somebody points out that there was either an abuse of power or an irregularity or an illegality in the entering into of that contract. The point is, something which we could not communicate effectively over the last 2 years. We've tried, but now that the Supreme Court is saying it, I hope the message will go throughout the country. There is a vast difference between choosing an economic policy and implementing that policy. If contracts have been entered into based on the choice of the policy, and there is nothing wrong in the nothing irregular or illegal in the implementation, obviously that contract will stand. Now, that is a general statement. Now, when it comes to individual departments and individual subjects, let the department look into the matter.
I think the finance minister has explained already. There is now a judgment of the court. We will apply the principles enunciated in the judgment to the specific issues that arise in the department.
Sir, do you think the judgment is a vindication of the argument that the CAG has exceeded its brief in the case of 2G report and call allocation report?
See, I don't want to comment on the CNAG's report today. The point is, the underlying premise of the CNAG's reports, the implied benchmark against which loss or presumptive loss was judged, was auction. That is the underlying premise. And to the extent that the opinion of the Supreme Court says that auction is not a constitutional mandate or an enshrined constitutional principle in disposing of natural resources, I sincerely hope that all constitutional authorities in future will bear that in mind while discharging their constitutional functions. In a way, all of us are in a learning process. And I think government learns and other constitutional authorities are part of the learning process.
I just want to add to that, and that is why I referred to you the Supreme Court opinion at page 118, and I reiterate it in the context of your question, where revenue maximization is not the object of a policy of distribution, the question of auction does not arise. That should answer your question.
Sir, as far as policy, difference between the policy and the implementation part is concerned, this relates to this government and also the previous government. So policies more or less in coal or in 2G, both were the same in the previous government and in this government also. The implementation part only Supreme Court has done what was required or what had to be done. Basically there the situation doesn't change. But moving forward, obviously this judgment has done one thing, is that the confusions have been removed. So how do you see the some kind of a cloud which was there on the due to the previous judgment which the government has to do the 2G auction? The government has targeted 40,000 crore from auction this year, and at the current reserve price there will be 15,000 crore. So how do you see is it an optimistic kind of a scenario from here? How do you see the finance minister effect?
The spectrum released by the re-auction, by the cancellation of the 122 licenses will be auctioned. Now, the reserve price has been kept at 14,000 crore. Now, what will be the realization in the auction, I cannot say. But I think we should realize a substantial and significant amount, because we have accepted the judgment that the 122 licenses will stand cancelled and the spectrum released from that cancellation will be auctioned. That was never an issue. That process will continue. What we will realize, I cannot say at the moment.
Sanjay, yes.
सिबल साहब, आपने 1.5 साल पहले हुए अपनी प्रेस कॉन्फ्रेंस का हवाला दिया है, उसमें आपने एक दावा किया था जीरो लॉस थ्योरी, और आपने कहा था कि शून्य नुकसान हुआ है सरकार को इस पूरे मामले में। आप मानते हैं कि जो सुप्रीम कोर्ट का निर्णय आया है वो कहीं ना कहीं आपके जीरो लॉस की थ्योरी को सत्यापित करता है?
नहीं, इसके बारे में मैं कोई टिप्पणी नहीं देना चाहता। फिर दोबारा वही सेंटेंस आपको करके बताऊंगा कि अगर रेवेन्यू मैक्सिमाइजेशन अपने आप में लक्ष्य नहीं है तो वहां ऑप्शन नहीं हो सकता। इससे ज्यादा मैं क्या कह सकता हूं? ये नहीं, देखिए, नहीं, शब्द इसलिए नहीं प्रयोग करेंगे कि दोबारा आप टीवी पे दिखाओ। जो समझने वाले समझ गए, जो ना समझे वो अनाड़ी है।
Yes, please, at the back.
सलमान साहब, मेरा आप क्योंकि हिंदी में आपसे मैं सवाल ही पूछ रहा था कि सीएजी के जो देखते सीएजी का काम जनरली सीएजी की रिपोर्ट्स लॉस के बारे में ही हमें पता चलता है उससे। तो अब जो कोर्ट ने कहा है, कल जो कोर्ट का जो ओपिनियन है, उसके बाद सीएजी के लिए तो बहुत बड़ी दिक्कत हो गई। अब तो कोई लॉस सीएजी की रिपोर्ट में आ ही नहीं सकता है स्टैंडर्ड।
नहीं, ऐसा नहीं है।
आई एम आस्किंग दिस, आई वांट टू अंडरस्टैंड इट।
नहीं, आप कुछ समझा रहे हैं
जी।
जो भी कानून देश का है और समय समय पर क्या कानून है, ये सुप्रीम कोर्ट से हमको इसके दिशा निर्देश प्राप्त होते हैं। तो जो कानून हमारी समझ से कल था उसको सामने रखकर हमने कोई निर्णय लिया। कई दफा सुप्रीम कोर्ट बाद में कहता है कि नहीं, ये कानून नहीं है, कानून कुछ और है। ये चर्चाएं सुप्रीम कोर्ट ने इस निर्णय में भी की हैं कि समय समय पर वो ओपिनियन देते हैं। क्या ओपिनियन देते समय पिछले ओपिनियन पर वो टिप्पणी कर सकते हैं, क्या उसको रिवर्स कर सकते हैं या उसमें कोई संशोधन कर सकते हैं, सुप्रीम कोर्ट ने इसमें रखा है। तो जो अंतिम निर्णय होता है उसी निर्णय के ही प्रकाश में हम लोगों को अपने निर्णय लेने होते हैं, चाहे हम हो और चाहे आप हो। जो हमको सीखना है और पढ़ना है, मैं समझता हूं मीडिया को भी सीखना और पढ़ना होगा इस जजमेंट को, क्योंकि अब इस जजमेंट के प्रकाश में ही हम लोग सारे ही अब निर्णय लेंगे और हमको लेने चाहिए। आगे कभी सुप्रीम कोर्ट में कुछ और निर्णय आता है तो तब हमें वो संशोधन हमको भी करने होंगे। सुप्रीम कोर्ट के सामने हम लोग सब अपने को ये मानते हैं कि हम सुप्रीम कोर्ट के कही हुई बात पर और उनके दिशा निर्देश पर ही चल सकते हैं। हमारे आगे और कोई रास्ता नहीं।
मैं आपको एक छोटी बात बता दूं कि हो सकता है आने वाले दिनों में कोई सीएजी कोई निर्णय को देखते हुए कहे कि इसमें केवल इस तरह से खर्चा हुआ, ये गलत तरीके से खर्चा हुआ और इससे नुकसान हुआ, तो वो लॉस की बात तो कर ही सकते हैं, लेकिन वो लॉस की बात नीति से नहीं जुड़ सकती। ये मोटी बात है।
सर, आपने फैसले का हवाला देकर कहा कि कोर्ट ने कहा है कि जहां पर रेवेन्यू कमाना मकसद नहीं हो वहां पे ऑक्शन तरीका नहीं हो सकता, लेकिन इस मामले में रेवेन्यू कमाना मकसद होगा या नहीं होगा, इसके बारे में सरकार की क्या पॉलिसी होगी?
वो तो तय करेगी ना हर नीति। जब भी कोई भी नेचुरल रिसोर्स, कोई भी प्राकृतिक संपदा, हम उसका तय करेंगे कि उसको हमने इस तरह से डिस्ट्रीब्यूट करना है, तो वो नीति हम बनाएंगे। उस नीति के आधार पे हम बताएंगे कि किस तरह से इसको डिस्ट्रीब्यूट करना है। समझ रहे हैं ना? तो इसलिए वो नीति जनता के सामने होगी। अगर उस नीति का ताल्लुक 39B से है, सामाजिक अच्छाई से है, तो उस नीति को कोई चैलेंज नहीं कर सकता। उसकी इंप्लीमेंटेशन को जरूर चैलेंज कर सकता है। तो ये सुप्रीम कोर्ट ने बड़े साफ तरीके से बता दिया।
Yes, Swaraj.
Mr. Chidambaram, sir, just for clarity's sake, I mean, if there is resource allocation through some other method, and it would appear that auction may be it would be a better route, or vice versa, does it mean that that process cannot be challenged, that policy cannot be challenged at all? I mean, even if it would seem that, maybe one route may be better than the other, but because of this judgment, it cannot be challenged at all.
See, in any kind of policy, there are always choices. The government of the day, the executive, is entitled to make that choice. Now, it's possible that a different set of people sitting in those offices could have arrived at a different conclusion. I mean, the famous statement of an English judge that two reasonable men can violently disagree without forfeiting the right to be called reasonable. Therefore, the government of the day is entitled to make the choice. And if a choice is made that in the circumstances that we find ourselves in, revenue maximization is not the first objective or the dominant objective, but some other objective has to be advanced, the government is entitled to make that choice, and the court will not, as reiterated here, will not review that decision. So the government's decision there will be final, and I don't think any other authority would be entitled to say that, no, in my view, that was not the choice you should have made, the other choice should have been made. That is not open to any authority except the executive.
Yes,
So,
please.
with Supreme Court now giving much clarity on auction of scarce natural resources, in any case, government is planning to reconsider or revisit the coal auction process, for which the process is already on. Any case, government may consider.
The government has already looked into the matter. Section 11 capital A has already been introduced into the Mines and Minerals Regulation Act. And Section 11 capital A has been referred to by the concurring judgment at page 202, and Justice Keher has clearly stated that in view of Section 11 capital A, which is there, you can read Section 11 capital A, it is extracted, the only manner in which it can be done is by auction, because 11 capital A starts by saying the central government may, for the purpose of granting reconnaissance permit, prospecting license or mining lease in respect of an area containing coal or lignite, select through auction by competitive bidding on such terms and conditions. Therefore, as far as coal and lignite are concerned, 11 capital A, which is the policy of the government of the day, approved by Parliament, prescribes auction as the only mode. There is no choice in the matter.
एक और बात सुप्रीम कोर्ट ने कही है इसी के संदर्भ में कि जब आप प्रोस्पेक्टिंग लाइसेंस माइन एंड मिनरल्स डेवलपमेंट एंड रेगुलेशन एक्ट में आप देते हो और जो एंटिटी आकर पैसा खर्च करके प्रोस्पेक्ट करती है, अगर उस एंटिटी को उसके बाद आप कहोगे कि आपको माइनिंग लाइसेंस नहीं मिलेगा, तो बाहर से निवेश आएगा कैसे? उन्होंने कहा है कि ये तभी सरकार तय करेगी कि किस तरह से इसको आगे बढ़ाना है। अगर किसी प्रोस्पेक्टिव लाइसेंस को आप ये कहो कि आप करोड़ों रुपया खर्च कर दो, उसके बाद आपको माइनिंग लाइसेंस नहीं मिलेगा, तो सुप्रीम कोर्ट कहती है तो इसके बाद आपका देश में निवेश आएगा कैसे? तो ये दायरा सरकार का है, ये निर्णय सरकार ने लेना है, लेकिन जो स्टैट्यूट कहता है उसको सामने रखते हुए, जैसे चिदम्बरम साहब ने कहा।
This section came into force on 13th of February 2012. 13th February 2012. So after 13th February 2012, the only manner in which coal and lignite can be allocated is by auction.
Sir, some clarity on an issue. You had answered it, but then again, I would beg the indulgence of asking that question again. Firstly, there are some answers which Supreme Court has not gone into what happens to that. And secondly, some curative petitions have been filed in the Supreme Court by some affected parties. What kind of impact will it have on those curative petitions?
Salman, you.
Well, we can't give you any response on matters that are pending before court. Obviously, you know, curative petitions are also based on the law as it stands, and it's for the judges to decide. It's not for us. And certainly, if there is anything in this judgment for parties before the court to utilize, they will be best advised to do so. But it's not for us to give any response on a matter that's pending before court.
And on this unanswered question,
As far as that is concerned, I've answered it again. I already answered it, namely that now that the judgment is with us and the principles are set out, what we have to do with questions that arise in respect of spectrum, we will decide in the context of the judgment.
Last question, please, Sumi.
The question is to the Law Minister. Sir, what is in the context of what there have been conflicting versions from the Attorney General, from the PMO on the MMRDA Act? This is what Mr. Chidambaram was talking about, was for coal and lignite. But what happens in the way they're saying for mining leases, it should be withheld. PMO says it should be withheld. Attorney General says till it goes through the Parliament, it is the law. First come, first serve basis, you can go ahead and allocate. What will happen in that kind of a situation now that there is no clarity? Because you already burnt your fingers once in the coal allocation, which happened in 2004 and then subsequently.
No, don't worry about burning fingers. We can wear gloves if need be, as you've seen now. We can wear constitutional gloves to protect ourselves. But I think this is an ongoing, evolving issue, and we can't really be taking a final view outside till such time as a final view is taken. It's actually just a matter of public policy that when you are waiting for certain formalities to be completed, what is the urgency, and in that urgency, what steps can you continue to take under an existing dispensation and regime, or would want to wait? Now, this is a policy decision that would be taken in due course with appropriate inputs that have come in from the law officers.
Thank you very much. Thank you. Please.